does owning a piece of land stop you from destroying the art that sits on it? That's really the question at the heart of our deep dive today. We're looking at this classic conflict. Does property ownership, this really old, powerful idea, does it ultimately trump, modern intellectual property rights? Our mission today is to unpack a really fascinating and pretty fiercely contested legal battle. Happened right in the middle of Manhattan. And this wasn't just some fight over real estate. It was a really high-profile showdown. You had this beloved community space on one side, and on the other, this powerful federal law specifically designed to protect, well, the moral rights of artists. We need to figure out how far the definition of art can actually stretch in a courtroom before it just, bang, hits the rigid boundary of legal precedent.
And the scene, as you said, is Lower Manhattan, the neighborhood known as Nolita, that's north of Little Italy. The place itself is the Elizabeth Street Garden. Now, for 3 decades, this space has been this amazing splash of green in a really, really dense concrete part of the city. It used to be just an abandoned lot, totally transformed over 30 years. It's now this vibrant, kind of unique public space filled with dozens of sculptures, plantings. It's really a testament to what a community can do, Conservation, creativity, all led by local people.
But the city owns the lot, right? And, well, they had other plans for it, affordable housing, I believe. So the community, facing this, they turned to a powerful but very specific legal tool to fight back.
Exactly. That tool is the Visual Artists' Rights Act. We usually call it VARA. Congress enacted it back in 1990. And VARA is absolutely crucial to this entire case.
Okay, let's break VARA down a bit for the listener.
Right.
Because it's not the same as copyright, is it?
No, definitely not. VARA grants artists something different, often called moral rights. It's a concept that's actually borrowed more from, European civil law traditions. Essentially, even if you sell the physical artwork, let's say a bronze statue or maybe a painting, the law ensures the artist keeps certain rights over how that piece is treated. Specifically, they have the right to prevent intentional destruction or modification or, alteration of a work if it has recognized stature.
Recognized stature, okay.
Yeah. So think of it like this. You buy the physical canvas, right? You own that. But the artist still has a kind of veto power over whether you can just, intentionally tear that canvas up or maybe paint over it. It's actually a pretty significant constraint on traditional property rights when you think about it.
Okay, that makes perfect sense for a traditional piece of art like a sculpture or a painting, something singular. But how on earth did the legal team for the Elizabeth Street Garden argue that an entire evolving living space, a garden could qualify for protection under a law seemingly meant for paintings and statues? That seems like a stretch.
Yeah. Well, that was the stretch. That was the really creative and frankly ambitious part of their whole lawsuit.
Right. So in February of 2025, the nonprofit that manages the garden, they sued New York City federal court. The goal was to stop the development.
Exactly. They knew VARA was probably their only real shot, legally speaking. And yeah, they made this highly ambitious argument.
Which was?
Their core argument was that the garden wasn't just, a collection of statues sitting amongst some flowers. It was, and this is their term, a unified physical and social sculpture.
Physical and social sculpture. Okay, that needs a bit of unpacking. It sounds academic.
It is, somewhat. The term social sculpture is often traced back to the artist Joseph Beuys, and it describes this concept where human activity, discussion, interaction, that's the actual fabric of the artwork itself. It's art that isn't static. It gets shaped by the community's involvement over time. So the nonprofit argued that these 3 decades of community effort, the curation, the integration of all these different art pieces, it created a single unified masterpiece. And that unified thing, they argued, deserved VIR protection from being destroyed.
Wow. That is a stunningly broad definition of art for a legal setting. But the context here is really critical, isn't it? The city's goal for developing the land wasn't just like building a mall. It was specifically for affordable housing.
Yes, that's absolutely key. This wasn't art versus commercial greed necessarily. It was VARA, this art protection law, going head-to-head with the city's legitimate claim of public need, using land they own for housing. So this case really became the ultimate test, you could say.
Yeah.
How far is the legal system willing to stretch the definition of a work of visual art, especially when it slams right into a city's property rights and its stated goal of, public welfare? Big collision.
So if the cultural world is maybe expanding its definition of art to include things like social practice, these big integrated installations, how did the law respond? What did the federal court actually say to this social sculpture argument? Did they buy it?
No, not really. In March 2025, so pretty quickly, the federal district court denied the garden's emergency request for an injunction. Basically, stop a development
They
now.
denied it.
Yeah.
So why?
Yeah.
Why couldn't they bridge that gap between the, let's say, cultural idea of art
hmm
and the strict legal definition? Was there just no precedent?
That's pretty much it. That's where the narrowness of VA itself became the main obstacle. The court's reasoning was very, very precise, surgical almost. It stuck right to the statutory definitions written in the law. They stress that VA's protection is limited. It's limited to specific traditional categories, things like paintings, sculptures, drawings, and certain limited editions of photographs. Pretty standard stuff.
Okay, so traditional category.
Right. And the problem for the garden was kind of twofold. First, the court saw the garden as an assemblage, like a site that contains sculptures. But it wasn't a single sculpture in and of itself. The court just couldn't get its head around the idea of a living, evolving, integrated installation fitting into these, discrete traditional boxes.
So the sum of the parts wasn't legally seen as a single whole, even if maybe in reality it functioned that way for the community.
Precisely. That nails it. And the second big hurdle was Vieira's definition of author and this concept of recognized stature. Vieira requires that the protection is tied to a specific creator, the author, and the work has to have recognized stature, which basically means critics, curators, art experts, the public generally agree it's significant work.
And the garden.
Well, because the Elizabeth Street Garden evolved over 30 years, right? Through the efforts of countless community members, volunteers, different artists contributing individual pieces over time. The nonprofit just couldn't meet Vieira's very rigid definition of being the single author of this supposed unified creation. And if you can't clearly name the author who holds the moral rights under the law, then the protection just can't be asserted. It fails.
Okay, this is where it gets really important for our listeners, especially those who track intellectual property.
Yeah.
The court wasn't necessarily saying the garden wasn't art in a general sense or that it wasn't valuable or beloved. Was it?
No, not at all. They were saying the law, VARA, as it's written, is a very rigid system. It's built on specific definitions. And if your creation doesn't fit neatly into the legal box, then your creative argument, doesn't matter how compelling it feels, it just can't overturn fundamental property rights in court.
So the law is the law, even when art is involved.
That really is the ultimate takeaway from the verdict, I think. Legal creativity, it has its limits. The court basically emphasized that VAR isn't some general tool for cultural preservation or, saving historic places. It's an intellectual property tool. It has a precise, limited scope. And that precision, that's what determines whether you win or lose in these cases.
Okay, let's pull back then and look at the broader implications. First off, what does this ruling mean for property owners? Let's say I own a big commercial building, and maybe someone commissions a huge, sprawling, site-specific installation across the lobby. Am I generally safe legally to modify it or even remove it later on?
Well, the implication for property owners, especially maybe municipalities or big developers, is pretty powerful. And property rights still hold incredibly strong, especially when faced with these non-traditional art claims under VAR. The case really reaffirms that owning land generally includes very broad, often unfettered rights over physical changes to that land. And that's probably doubly true when those changes involve some kind of public necessity, like the housing argument here, or maybe infrastructure.
So owners can breathe a little easier.
Reasonably so, yes. Property owners can likely proceed with the expectation that if the art doesn't clearly fall into those specific VARA definitions, painting, drawing, traditional sculpture, the chance of a successful moral rights injunction stopping them is, well, pretty low. Courts seem unlikely to grant sweeping protections for complex, non-traditional installations, especially ones that incorporate landscape or, changing elements over time.
Okay, now let's flip that around. What about for the artists, for creators, for IP holders who actually want to secure moral rights over public work, maybe site-specific stuff? What's the strategic lesson here?
Yeah, for artists and creators, the ruling is maybe a harsh reminder, but probably a necessary one. VA protections are statutory. They're written down, and they are interpreted narrowly by courts. So the key lesson really is about precision and, crucially, advanced planning. You can't wait until there's a problem. If you want to successfully assert moral rights over public space or a big installation, you really need to do two things before any conflict comes up. First, structure the artwork itself so it falls as clearly as possible squarely into one of VA's protected categories. Either make it a traditional medium, or if it is an installation, maybe make sure the individual components are clearly defined as, say, sculptures or qualifying photographs under the law.
Define it legally from the start.
Exactly. And second, the creator, or creators, must clearly establish their authorship from the very beginning, legally. In complex projects, especially community ones like the garden, this might mean creating specific contracts or legal documents. These documents need to define a single entity, or maybe specific individuals, as the legally recognized author of the unified work, even if there's a lot of collaboration involved. Nail down the authorship.
Okay, so structure it right, document the author. But what if VAR is just too narrow for certain kinds of projects, like the Elizabeth Street Garden seemed to be? Are there other ways? What alternatives exist to protect these kinds of community-driven spaces from development?
That's really the critical practical question, isn't it? If VAR isn't the right tool, maybe because the work is too integrated or authorship is too diffuse, then communities and artists really need to look towards land use tools instead. Probably the most robust alternative is something called a conservation easement.
A conservation easement. Explain that briefly for us.
Sure. So, for listeners maybe unfamiliar with the term, a conservation easement is basically a voluntary legal agreement. It's between a landowner, which, in a case like this, ideally might be a community land trust that acquires the property, and an easement holder. The holder is usually a qualified nonprofit land trust or sometimes a government agency. And what this agreement does is it permanently restricts the development rights on that specific piece of property. It limits what can be done there. The goal is to protect its defined features, which could be ecological, historical, or, this is key here, cultural or artistic features.
Ah, okay. So that shifts the protection away from intellectual property rights, which are tied to the creator,
Yeah.
and moves it towards land protection law, which is tied to the actual physical asset, the land itself.
Exactly. The protection gets baked right into the deed of the property. It becomes legally binding on all future owners of that land. Doesn't matter who the author was. So while the Elizabeth Street Garden case really highlights the limitations, maybe the failure of using VRA for this kind of holistic landscape preservation, it also really shines a light on the need for artists and community groups to think about using these more sophisticated land use tools, things like easements. And crucially, they need to do it in advance to secure the long-term future of these kinds of unique creations. Waiting until the bulldozers are literally scheduled, well, that's almost always too late.
This has been such a critical deep dive, really fascinating. We've clearly seen this clash, haven't we, between a dynamic, creative, almost communal definition of art,
Yeah.
as a powerful idea of a social sculpture, and then the very precise, often quite rigid contours of legal protections under existing IP laws like VAR. It just highlights these vital questions about the future of art in our public spaces, and ultimately, who gets to decide its fate? Property owner? Creator? Community?
Indeed. And the Elizabeth Street Garden case, I think, leaves us with a final, maybe provocative thought for you to consider. If a community invests decades of real effort transforming an abandoned derelict lot into something truly unique, functional, beautiful, filled with art, should the law evolve somehow? Should it find a way to formally recognize and protect these social sculptures or these complex integrated installations? Or must property rights always remain the kind of immovable, untouchable foundation of ownership, even when significant cultural assets are potentially at stake? It really reminds us that gaining solid legal protection for complex, evolving public art requires far more planning, much clearer legal definition, and probably more statutory foresight than just, the act of creating the art itself.